Good day everyone. We will going to discuss the Republic Act number 9165, an act instituting the Comprehensive Dangerous Drugs Act of 2002. The discussants, we have here Mrs. Eden Ross T. Camat and Ms. Annabelle F. Tatulo. So the objectives we have here to discuss the policy of Comprehensive Dangerous Drugs Act, define the use of dangerous act, determine the impact of dangerous drugs on individuals, society, family, and group, state the penalty of the offenders in the Dangerous Drugs Act. Introduction. This act, consisting of 101 sections, provides for the importation of dangerous drugs and or controlled precursors and essential chemicals. It establishes offenses and penalty according to the different dangerous drugs, regardless of the quantity, and dangerous drugs and or controlled precursor and essential chemicals shall maintain and keep an original record of sales, purchases, acquisitions, and deliveries of dangerous drugs, indicating specific information. It is the policy of the state to safeguard the integrity of its territory and the well-being of its citizenry, particularly the youth, from the harmful effects of dangerous drugs on their physical and mental well-being, and to defend the same against acts of omissions detrimental to their development and preservation. Unlawful acts and penalties. Section 4, importation of dangerous drugs and or controlled precursors and essential chemicals. We have the offenders and its penalty. First, we have importer, penalty life to death plus 500,000 to 10 million pesos. Offenders, second, importer using diplomatic passport, penalty death plus 10 million pesos. Offenders, third, financier, organizer, manager of importation, penalty death plus 10 million pesos. Offenders, fourth, protector, coddler, penalty 12 years and 1 day to 20 years plus 100,000 pesos to 500,000 pesos. Section 5. Sale, trading, administration, dispensation, delivery, distribution, and transportation of dangerous drugs and or controlled precursors and essential chemicals. Acts, we have the sale, trade, distribute, transport, broker. The penalty here, we have the life to death plus 500,000 pesos to 10 million pesos. Maximum penalty imposed on: first, committed within 100 meters from a school; second, use of minors or mentally incapacitated person as runners, couriers, and messengers, or in any other capacity; third, if the victim is a minor or mentally incapacitated; fourth, dangerous drug is the proximate cause of death of victim; fifth, organizer manages the unlawful acts, financier, protector, coddler, 12 years plus 1 day to 20 years plus 100,000 pesos to 500,000 pesos. Section 6. Maintenance of a den, dive, or resort. A place where any dangerous drug or controlled precursor and essential chemical is administered, delivered, stored for illegal purposes, distributed, sold, or used in any form. Maintenance, life to death plus 500,000 pesos to 10 million pesos fine. Caters to minor clients, death plus 10 million pesos fine. Financier, death plus 10 million pesos fine. Protector, coddler, 12 years and 1 day to 20 years plus 100,000 pesos to 500,000 pesos fine. Clients dies, death plus 1 million pesos to 15 million pesos fine. Section 7. Employees and visitors of a den, dive, or resort. Imprisonment, we have here 12 years, 1 day to 20 years, plus fine of 100,000 pesos to 500,000 pesos. Any employee of a den, dive, place as such, and any person who, not being included in the provisions of the next preceding paragraph, is aware of the nature of the place as such shall knowingly visit the same. Review Section 8, Manufacture of dangerous drugs and or controlled precursors and essential chemicals. Penalty: financier of 12 years and 1 day to 20 years of imprisonment and a fine ranging from 100,000 pesos to 500,000 pesos. Life imprisonment, 500,000 pesos to 10 million pesos. Penalty of imprisonment ranging from 12 years and 1 day to 20 years and a fine ranging from 100,000 pesos to 500,000 pesos. Any phase of the manufacturing process was conducted in the presence of with the help of minors. Any phase of manufacturing process was established or undertaken within 100 meters of a residential, business, church, or school premises. Any clandestine laboratory was secured or protected with booby traps. Any clandestine laboratory was concealed with legitimate business operations, or any employment of a practitioner, chemical engineer, public officials, or foreigner. Penalty of imprisonment ranging from 12 years and 1 day to 20 years and a fine ranging from 100,000 pesos to 500,000 pesos. Any phase of the manufacturing process was conducted in the presence or with the help of minors. Any phase or manufacturing process was established or undertaken within 100 meters of a residential, business, church, or school premises. Any clandestine laboratory was secured or protected with the booby traps. Any clandestine laboratory was concealed with legitimate business operations, or any employment of a practitioner, chemical engineer, public official, or foreigner. Section 9. We have illegal chemical diversion of controlled precursors and essential chemicals. Penalty: imprisonment, 12 years and 1 day to 20 years and a fine ranging from 100,000 pesos to 500,000 pesos. Shall be impressed upon any person who, unless authorized by law, shall illegally divert any controlled precursor and essential chemical. Section 10. Manufacture or delivery of equipment, instrument, apparatus, and other paraphernalia for dangerous drugs and or controlled precursors and essential chemicals. The penalty of imprisonment ranging from 12 years and 1 day to 20 years and a fine ranging 100,000 pesos to 500,000 pesos. The penalty of imprisonment ranging from 6 months and 1 day to 4 years and a fine ranging from 10,000 pesos to 50,000 pesos shall be imposed upon any person who shall deliver, possess with intent to deliver, or manufacture with intent to deliver equipment, instrument, apparatus, and other paraphernalia for dangerous drugs. These shall be imposed if it will be used to inject, ingest, inhale, or otherwise introduce into the human body and a dangerous drug in violation of this act. See, the maximum penalty provided for under this section shall be imposed upon any person who uses a minor or a mentally incapacitated individual to deliver such equipment, instrument, apparatus, and other paraphernalia for dangerous drugs. Section 11. Possession of dangerous drugs. The penalty of life imprisonment to death and a fine ranging from 500,000 pesos to 10 million pesos shall be imposed upon any person who, unless authorized by law, shall possess any dangerous drug in following quantities, regardless of the degree of purity thereof. First, we have 10 grams or more of opium. Second, 10 grams or more of morphine. Third, 10 grams or more of heroin. Fourth, 10 grams or more of cocaine or cocaine hydrochloride. Fifth, 50 grams or more of methamphetamine, hydrochloride, or shabu. 6. 10 marijuana resin oil. 7. 500 grams or more of marijuana. And 8. We have the 10 grams or more of other dangerous drugs. Elements we have here: first, person is in possession that is identified to be a prohibited drug. Second, such possession is not authorized by law. Third, person freely and consciously possessed the said prohibited drug. Section 12. Possession of equipment, instrument, apparatus, and other paraphernalia for dangerous drugs. The penalty of imprisonment ranging from 6 months and 1 day to 4 years, and a fine ranging from 10,000 pesos to 50,000 pesos shall be imposed upon any person who, unless authorized by law, shall possess or have under his or her control any equipment, instrument, apparatus, and other paraphernalia fit or intended for smoking, consuming, administering, injecting, ingesting, or introducing any dangerous drug into the body. Section 13. Possession of dangerous drugs during parties, social gatherings, or meetings. Any person found possessing any dangerous drug during a party or at a social gathering or meeting, or in the proximate company of at least 2 persons, shall suffer the maximum penalties provided for in Section 11 of this Act, regardless of the quantity and purity of such dangerous drugs. Section 14. We have the possession of equipment, instrument, apparatus, and other paraphernalia for dangerous drugs during parties, social gatherings, or meetings. The maximum penalty provided for in Section 12 of this Act shall be imposed upon any person who shall possess or have under his or her control any equipment, instrument, apparatus, and other paraphernalia fit or intended for smoking, consuming, administering, injecting, ingesting, or introducing any dangerous drug into the body during parties, social gatherings, or meetings, or in proximate company of at least 2 persons. We have here Section 15. Use of dangerous drugs. We have the penalty. Penalty of imprisonment ranging from 6 years and 1 day to 12 years, and a fine ranging from 50,000 pesos to 200,000 pesos. A person apprehended or arrested who is found to be positive for use of any dangerous drug after a confirmatory test shall be imposed a penalty of maximum of 6 months rehabilitation in a government center for the first offense. Section 16. Cultivation or culture of plants classified as dangerous drugs or are sources thereof. Penalty. The penalty of life imprisonment to death and a fine ranging from 500,000 pesos to 10 million pesos. The penalty of 12 years and 1 day to 20 years of imprisonment and a fine ranging from 100,000 pesos to 500,000 pesos shall be imposed upon any person who shall plant, cultivate, or culture marijuana, opium poppy, or any other plant regardless of quantity, which is or may thereafter be classified as dangerous drug, or as a source from which any dangerous drug may be manufactured or derived, shall be imposed upon any person who acts as a Section 16. Cultivation or culture of plants classified as dangerous drugs or are sources thereof. Penalty. The penalty of life imprisonment to death and a fine ranging from 500,000 pesos to 10 million pesos. The penalty of 12 years and 1 day to 20 years of imprisonment and a fine ranging from 100,000 pesos to 500,000 pesos. A shall be imposed upon any person who shall plant, cultivate, or culture marijuana, opium poppy, or any other plant regardless of quantity, which is or may hereafter be classified as a dangerous drug, or as a source from which any dangerous drug may be manufactured or derived. B shall be imposed upon any person who acts as a protector, toddler, We have the section 17, maintenance and keeping of original records of transactions on dangerous drugs and or controlled precursors and essential chemicals. Penalty. The penalty of imprisonment ranging from 1 year and 1 day to 6 years, and a fine ranging from 10,000 pesos to 15,000 pesos. A shall be imposed upon any practitioner, manufacturer, wholesaler, importer, distributor, dealer, or retailer who violates or fails to comply with the maintenance and keeping of the original records of transactions on any dangerous drug and or controlled precursor and essential chemical in accordance with the section 40 of this act. B. We have the additional penalty shall be imposed through the revocation of the license of the practice to practice his or her profession in case of a practitioner of the business, in case of a manufacturer, reseller, importer, distributor. Section 18, unnecessary prescription of dangerous drugs penalty. The penalty of imprisonment ranging from 12 years and 1 day to 20 years, and a fine ranging from 100,000 pesos to 500,000 pesos. A shall be imposed upon the practitioner who shall prescribe any dangerous drug to any person whose physical or physiological condition does not require the use or in the dosage prescribed therein, as determined by the board in consultation with recognized competent experts who are authorized representatives of professional organizations of practitioners, particularly those who are involved in the care of persons with severe pain. Section 19, unlawful prescription of dangerous drugs. The penalty of life imprisonment to death, a fine ranging from 500,000 pesos to 10 million pesos shall be imposed upon any person who, unless authorized by law, shall make or issue a prescription or other writing supporting to be prescription for any dangerous drug. Section 20. Confiscation and forfeiture of the proceeds or instruments of the unlawful act, including the properties or proceeds derived from the illegal trafficking of dangerous drugs and or precursors and essential chemicals. Every penalty imposed for the unlawful importation, sale, trading, administration, dispensation, delivery, distribution, transportation, or manufacture of any dangerous drug and or controlled precursor and essential chemical, the cultivation or culture of plants which are sources of dangerous drugs, and the possession of any equipment, instrument, apparatus, and other paraphernalia for dangerous drugs, including other laboratory equipment. Section 21. Custody and disposition of confiscated, seized, and or surrendered dangerous drugs, plant sources of dangerous drugs, controlled precursors, and essential chemicals, instruments, paraphernalia, and or laboratory equipment. The PDEA or the PDEA shall take charge and have custody of all dangerous drugs, plant sources of dangerous drugs, controlled precursors, and other chemicals, as well as instrument, paraphernalia, and or laboratory equipment, so confiscated, seized, and or surrendered for proper disposition in the following manner. We have the section 22, grant of compensation, reward, and award. The board shall recommend to the concerned government agency the grant of compensation, reward, and award to any person providing information and to law enforcers participating in the operation which results in the successful confiscation, seizure of surrender of dangerous drugs, plants, sources of dangerous drugs, and controlled precursors and essential chemicals. We have here the section 23, plea bargaining provision. Any person charged under any provision of this act, regardless of the impossible penalty, shall be allowed to avail of the provision of plea bargaining. Section 24, non-applicability of the provision law for drug trafficking and pushers. Any person convicted for drug trafficking Revision Law of the Presidential Decree number 968 as a Section 25, qualifying aggravating circumstances in the commission of a crime by an offender under the influence of dangerous drugs. Notwithstanding the provisions of any law to the contrary, a positive finding for the use of dangerous drugs shall be a qualifying aggravating circumstance in the commission of a crime by an offender, and the application of the penalty provided for in the revised penal code shall be applicable. Section 26. Attempt or conspiracy. Any attempt or conspiracy to commit the following unlawful acts shall be penalized by the same penalty prescribed by the commission of the same as provided under this Act.
Section 27. Criminal liability of a public officer or employee for misappropriation, misapplication, or failure to account for the confiscated, seized, and or surrendered dangerous drugs, plant sources of dangerous drugs, controlled precursors and essential chemicals, instruments, paraphernalia, and or laboratory equipment, including the proceeds or properties obtained from the unlawful act committed. The penalty of life imprisonment to death and a fine ranging from 500,000 pesos to 10 million pesos. Section 28. Criminal liability of government officials and employees. The maximum penalties of the unlawful acts provided for in this act shall be imposed, in addition to absolute perpetual disqualification from any public office, if those found guilty of such unlawful acts are government officials and employees. Section 29. Criminal liability for planting of evidence. Any person who is found guilty of planting any dangerous drug and or controlled precursor and essential chemical, regardless of quantity and purity, shall suffer the penalty of death. Section 30. Criminal liability of officers of partnerships, corporations, associations, and other juridical entities. In case any violation of this act is committed by a partnership, corporation, association, or any juridical entity, the partner, president, director, manager, trustee, state, administrator, or officer who consents to unknowingly tolerate such violation shall be held criminally liable as a co-principal. Section 31. Additional penalty is offender is an alien. In addition to the penalties prescribed in the unlawful act committed, any alien who violates such provisions of this act shall, after service of sentence, be deported immediately without further proceedings unless the penalty is death. Section 32. Liability to a person violating any regulation issued by the court. The penalty of imprisonment ranging from 6 months and 1 day to 4 years, and a fine ranging from 10,000 pesos to 50,000 pesos. Section 33. Immunity from prosecution and punishment. Shall be exempted from prosecution and punishment for the offense with reference to which his or her information of testimony were given. It may plead or prove the giving of such information and testimony in bar of such prosecution. Section 34. Termination of the grant of immunity. The immunity granted to the informant or witness as prescribed in Section 33 of this Act shall not attach should it turn out subsequently that information and testimony is false, malicious, or made only for the purpose of harassing, molesting, or any way prejudicing the persons described in the proceeding. Section 35. Accessories. Penalties. A person convicted under this act shall be disqualified to exercise his or her civil rights, such as but not limited to the rights of parental authority or guardianship, either as to the person or property of anyone, the rights to dispose of such property by any act or any conveyance, enter vivos, and political rights such as but not limited to the right to vote and be voted for, Section 36. Authorized drug testing. Authorized drug testing shall be done by any government forensic laboratories or by any of the drug testing laboratories accredited and monitored by the Department of Health to safeguard the quality of test result. The Department of Health shall take steps in setting the price of drug test, which with Department of Health accredited drug testing centers to further reduce the cost of such drug test. Section 37. Issuance of false or fraudulent drug test result. Penalty. Penalty of imprisonment ranging from 6 years and 1 day to 12 years and a fine ranging from 100,000 pesos to 500,000 pesos. Section 38. Laboratory examination or test on apprehended arrested offenders. Subject to Section 15 of this Act, any person apprehended or arrested for violating the provision of this Act shall be subjected to screening laboratory examination or test within 24 hours. Section 39. Accreditation of drug testing centers and physicians. The Department of Health shall be tasked to license and accredit drug testing centers in each province and city in order to assure their capacity, competence, integrity, and stability to conduct the laboratory examination and test provided in this article, and appoint such technical and other personnel as may be necessary for the effective implementation of this provision. Section 40. Records required for transaction on dangerous drugs and precursors and essential chemicals. Every pharmacist dealing in dangerous drugs and or controlled precursors and essential chemicals shall maintain and keep an original record of sales, purchases, acquisition, and deliveries of dangerous drugs. Article 4. Participation of the family, students, teachers, and school authorities in the enforcement of this Act. Section 41. Involvement of the family. The family, being the basic unit of the Filipino society, shall be primarily responsible for the education and awareness of the members of the family on the ill effects of dangerous drugs and close monitoring of family members who may be susceptible to drug abuse. Section 42. Student councils and campus organizations. All elementary, secondary, and tertiary schools, students, councils, and campus organizations shall include in their activities a program for the prevention of and deterrence in the use of dangerous drugs, the referral for treatment and rehabilitation of students for drug dependence. Section 43. School Curricula. Instruction on drug abuse prevention and control shall be integrated in the elementary, secondary, and tertiary curricula of all public and private schools, whether general, technical, vocational, or agro-industrial, as well as in non-formal, informal, and indigenous learning systems. Section 44. Heads, supervisors, and teachers of schools. For the purpose of enforcing the provisions of Article 2 of this Act, all school heads, supervisors, and teachers shall be deemed persons in authority, and such are hereby empowered to apprehend, arrest, or cause the apprehension or arrest of any person who shall violate any of the said provision pursuant to Section 5, Rule 113 of the Rules of the Court. Section 45. Publication and distribution of materials on dangerous drugs. With the assistance of the Board, the Secretary of the Department of Education, the Chairman of the Commission on Higher Education, and the Director General of the Technical Education and Skills Development Authority shall cause the development, publication, and distribution of information and support educational materials on dangerous drugs to the students, the faculty, the parents, and the community. the Department of Social Welfare and Development shall establish in each of its provincial office a special education drug center for out-of-school youth and street children. Article 5. Promotion of a national drug-free workplace program with the participation of private and labor sectors and the Department of Labor and Employment. Section 47. Drug-free workplace. It is deemed a policy of the state to promote drug-free workplaces using a tripartite approach with the assistance of the board. The Department of Labor and Employment shall develop, promote, and implement a national drug abuse prevention program in the workplace to be adopted by private companies with 10 or more employees. Section 48. Guidelines for the National Drug-Free Workplace Program. The board and the DOLE shall formulate the necessary guidelines for the implementation of the National Drug Workplace Program. The amount necessary for the implementation of which shall be included in the Annual General Appropriations Act. Article 6. Participation of the private and labor sectors in the enforcement of this Act. Section 49. Labor organizations in the private sector. All labor unions, federations, associations, or organizations in cooperation with the respective private sector partners shall include in their collective bargaining or any similar agreements, joint continuing programs and information campaigns for the laborers similar to the programs provided under Section 47 of this Act with the end in view of achieving a drug-free workplace. Section 50. Government assistance. The labor sector and the respective partners may, in pursuit of the programs mentioned in the preceding section, secure the technical assistance, such as, but not limited to, seminars and information dissemination campaigns of the appropriate government and law enforcement agencies. Article 7. Participation of local government units. Section 51. Local government units assistant. Local government units shall appropriate a substantial portion of their respective annual budgets to assist and or enhance the enforcement of this Act, giving priority to preventive or educational programs in the rehabilitation or treatment of drug dependence. Section 52. Abatement of drug-related public nuisances. Any place or premises which have been used on 2 or more occasions as the site of the unlawful sale or delivery of dangerous drugs may be declared to be a public nuisance. Section 53. Effect of board declaration. If the board declares a place or premises to the public nuisance, it may declare an order immediately prohibiting the conduct, operation, or maintenance of any business or activity on the premises which is conducive to such nuisance. An order entered under section shall expire after 1 year or at such earlier time as stated in the order. Article 8. Program for treatment and rehabilitation of drug dependence. Section 54. Voluntary submission of a drug dependent to confinement, treatment, and rehabilitation. A drug dependent or any person who violates Section 15 of this Act may, by himself or herself, or through his or her parent, spouse, guardian, or relative within the 4th degree of consanguinity or affinity, apply to the board or its duly recognized representative for treatment and rehabilitation of drug dependency. Section 55. Exemption from the criminal liability under the voluntary submission program. A drug dependent under the voluntary submission program who is finally discharged from confinement shall be exempt from the criminal liability under Section 15. Section 56. Temporary release from the center after care and follow-up treatment under the voluntary submission program. Upon certification of the center that the drug dependent within the voluntary submission program may be temporarily released, the court shall order his or her release on condition that said drug dependent shall report to the Department of Health for aftercare and follow-up treatment, including urine testing for a period not exceeding 18 months under such terms and conditions that the court may impose. Section 57. Probation and community service under the voluntary submission program. A drug dependent who is discharged as rehabilitated by the Department of Health accredited center through the voluntary submission program but does not qualify for exemption from criminal liability under Section 55 of this Act may be charged under the provisions of this Act but shall be placed on probation and undergo a community service in lieu of imprisonment and or fine in the discretion of the court without prejudice to the outcome of any pending case filed in court. Section 58. Filing of charges against a drug dependent who is not rehabilitated under the voluntary submission program. A drug dependent who is not rehabilitated after the second commitment to the center under the voluntary submission program shall, upon recommendation of the board, be charged for violation of Section 15 of this Act as prosecute like any other offender. If convicted, he or she shall be credited for the period of confinement and rehabilitation in the center in the service of his or her sentence. Section 59. Escape and recommitment for confinement and rehabilitation under the voluntary submission program. Should a drug dependent under the voluntary submission program escape from the center, he or she may submit herself for recommitment within 1 week there from his or her parent, spouse, guardian, or relative within the fourth degree of consanguinity or affinity may within said period surrender him or recommitment, in which case of corresponding shall be issued by the board. Section 60. Confidentiality of records under the voluntary submission program. Judicial and medical records of drug dependents under the voluntary submission program shall be confidential and shall not be used against him for any purpose except to determine how many times by himself or herself or through his or her parent, spouse, guardian, or relative within the fourth degree of consanguinity or affinity he or she voluntarily submitted himself or herself for confinement treatment and rehabilitation or has been committed to a center under this program. Section 61. Compulsory confinement of a drug dependent who refuses to apply under the voluntary submission program, notwithstanding any law, rule, and regulation to the contrary, any person determined and found to be dependent on dangerous drugs shall, upon petition by the board or any of its authorized representative, be confined for treatment and rehabilitation in any center duly designated or accredited for the purpose. Section 62. Compulsory submission of a drug dependent charged with the offense to treatment and rehabilitation. If a person charged with an offense where the imposable penalty is imprisonment of less than 6 years and 1 day and it is found by the prosecutor or by the court at any stage of the proceedings to be a drug dependent, the prosecutor or the court, as the case may be, shall suspend all further proceedings and transmit copies of the record of the case of the board. Section 63. Prescription of the offense charged against a drug dependent under the compulsory submission program. The period of prescription of the offense charged against a drug dependent under the compulsory submission program shall not run during the time that the drug dependent is under confinement in a center or otherwise under the treatment and rehabilitation program approved by the board. Section 64. falls under the compulsory submission program. The records of a drug dependent who was rehabilitated and discharged from the center under the compulsory submission program who was charged for violation of Section 15 of this Act shall be covered by Section 60 of this Act. However, the records of a drug dependent who was not rehabilitated or who escaped but did not surrender himself or herself within the prescribed. Section 65. Duty of the prosecutor in the proceedings. It shall be the duty of the provincial or the city prosecutor or their assistants or state prosecutors to prepare the appropriate petition in all proceedings arising from this Act. Section 66. Suspension of sentence of a first-time minor offender. An accused who is over 15 years of age at the time of the commission of the offense mentioned in Section 11 of this Act, but not more than 18 years old at the age time when judgment should have been promulgated after having been found guilty of said offense, may be given the benefits of a suspended sentence. Section 67. Discharge after compliance with conditions of suspended sentence of a first-time minor offender. If the accused first-time minor offender under suspended sentence complies with the applicable rules and regulations of the board, including confinement in a center, the court, upon a favorable recommendation of the board for the final discharge of the accused, shall discharge the accused and dismiss all proceedings. Section 68. Privilege of suspended sentence to be availed of only once by a first-time minor offender. The privilege of suspended sentence shall be availed of only once by an accused drug dependent who is a first-time offender over 15 years of age at the time of the commission of violation of Section 15 of this Act, but not more than 18 years of age at time when judgment should have been promulgated. Section 69. Promulgation of sentence for first-time minor offender. If the accused first-time minor offender violates any of the conditions of his or her suspended sentence, the applicable rules and regulation of the board exercising supervision and rehabilitative surveillance over him, including the rules and regulation of the center. Should confinement be required, the court shall pronounce judgment of conviction and he or she shall serve sentence as any other convicted person. Section 70. Probation or community service for a first-time minor offender in lieu of imprisonment. Upon promulgation of the sentence, the court may, in its direct discretion, place the accused under probation, even if the sentence provided under this Act is higher than that provided under existing law or probation, or impose community service in lieu of imprisonment. Section 71. Records to be kept by the Department of Justice. The Department of Justice shall keep a confidential record of the proceedings on suspension of sentence and shall not use any purpose other than to determine whether or not a person accused under this Act is a first-time minor offender. Section 72. Liability of a person who violates the confidentiality of records. The penalty of imprisonment ranging from 6 months and 1 day to 6 years and a fine ranging from 1,000 pesos to 6,000 pesos shall impose upon any person who, having official custody of or access to the confidential records of any drug dependent under voluntary submission programs, or anyone who, having gained possession of said records, whether lawfully or not, reveals their content to any person other than those charged with the prosecution of the offenses under this Act and its implementation. Section 73. Liability of a parent, spouse, or guardian who refuses to cooperate with the board or any concerned agencies. Any parent, spouse, or guardian who, without valid reason, refuses to cooperate with the board or any concerned agencies in the treatment and rehabilitation of drug dependent who is minor or in any manner prevents or delays the aftercare, follow-up, or other programs for the welfare of the accused drug dependent, whether under voluntary submission program or compulsory submission program, may be cited for contempt by the court. Section 74. Cost sharing and the treatment and rehabilitation of drug dependent. The parent, spouse, guardian, or any relative within the fourth degree of consanguinity of any person who is confined under the voluntary submission program or compulsory submission program shall be charged a certain percentage of cost of his or her treatment and rehabilitation, the guidelines of which shall be formulated by the DSWD taking into consideration the economic status of the family of the person confined. A social worker of the local government unit shall implement the guidelines therein formulated. Section 75. Treatment and Rehabilitation Centers. The existing treatment and rehabilitation centers for drug dependents operated and maintained by the NBI and the PNP shall be operated, maintained, and managed by the Department of Health in coordination with other concerned agencies. The national government, through its appropriate agencies, shall give priority funding for the increase of subsidy to existing government drug rehabilitation centers and shall establish at least one drug rehabilitation center in each province, depending on the availability of funds. Section 76. The duties and responsibilities of Department of Health under this Act. First, oversee and monitor the integration, coordination, and supervision of all drug rehabilitation intervention. Second, license, accredited, establish and maintain drug test network and laboratory, initiate, conduct, and support scientific research on drugs and drug control. Third, encourage, assist, and accredit private centers, promulgate rules and regulation. Fourth, prescribe and promulgate rules and regulation governing the establishment of such centers. Fifth, the Department of Health shall, without prejudice to the criminal prosecution of those found guilty of violating this act. Sixth, charge reasonable fees for drug dependency examinations, other medical and legal services provided to the public. Article 9. Dangerous Drugs Board and Philippine Drug Enforcement Agency. Section 77. The Dangerous Drugs Board shall be the policy-making and strategy formulating body in the planning and formulation of policies and programs on drug prevention and control. It shall develop and adopt a comprehensive, integrated, unified, and balanced national drug abuse prevention and control strategy. It shall be under the office of the President. Section 78. Composition of the Board. The Board shall be composed of 17 members, wherein 3 of which are permanent members. The other 12 members shall be in an ex officio capacity, and the 2 shall be regular members. The 3 permanent members who shall possess at least 7-year training and experience in the field of dangerous drugs and in any of the following fields: in law, medicine, criminology, psychology, or social work, shall be appointed by the President of the Philippines. Section 79. Meetings of the Board. The Board shall meet once a week or as often as necessary at the discretion of the Chairman or at the call of any 4 other members. The presence of 9 members shall constitute a quorum. Section 80. Secretariat of the Board. The Board shall recommend to the President of the Philippines the appointment of an Executive Director with the rank of an Undersecretary, who shall be the Secretary of the Board and Administrative Officer of its Secretariat, and shall perform such other duties that may assign to him or her. Section 81. Powers and duties of the Board. The Board shall formulate, develop, and establish a comprehensive, integrated, unified, and balanced national drug use prevention and control strategy. Promulgate such rules and regulations as may be necessary to carry out the purpose of this act, including the manner of safekeeping, disposition, burning of, condemnation of any dangerous drug. Next, conduct the policy studies, program monitoring, evaluations, and other researches on drug prevention, control, and enforcement. Illustrate, conduct, and support scientific, clinical, social, psychological, physical, and biological researches on dangerous drugs and dangerous drugs prevention and control measures. Next, develop an educational program and information drive on the hazards and prevention of illegal use of any dangerous drug and or controlled precursor. Section 82. Creation of the Philippine Drug Enforcement Agency or PDEA. To carry out the provisions of this act, the PDEA, which serves as an implementing arm of the board, and shall be responsible for the efficient and effective law enforcement of all provisions on any dangerous drug and or controlled precursor and essential chemical as provided in this act. Section 83. Organization of the PDEA. The present Secretariat of the National Drug Law Enforcement and Prevention Coordinating Center, as created by Executive Order Number 61, shall be accordingly modified and absorbed by the PDEA. The Director General of the PDEA shall be responsible for the necessary changes in the organizational setup, which shall be submitted to the Board for approval. Section 84. Powers and duties of the PDEA. The PDEA shall implement or cause the efficient and effective implementation of the National Drug Control Strategy formulated by the Board, thereby carrying out a national drug campaign program, which shall include drug law enforcement, control, and prevention campaign with the assistance of concerned government agencies. Section 85. The PDEA Academy. Upon the approval of the Board, the PDEA Academy shall be established either in Baguio or Tagaytay City, and in such other places as may be necessary. The PDEA Academy shall be responsible in the recruitment and training of all PDEA agents and personnel. The Board shall provide for the qualification and requirements of its recruits, who must be at least 21 years of age, of proven integrity and honesty, and a baccalaureate degree holder. Section 86. Transfer, absorption, and integration of all operating units on illegal drugs into the PDEA and transitory provisions. The Narcotics Group of the PNP, the Narcotics Division of the NBI, and the Customs Narcotics Interdiction Unit are hereby abolished. However, they shall continue with the performance of their tasks as detailed service with the PDEA, subject to screening until such time the organizational structure of agency is fully operational and the number of graduates of the PDEA Academy is sufficient to do the task themselves. Article 10. Appropriations Management of Funds and Annual Report. Section 87. Appropriations. The amount necessary for the operation of the board and the PDEA shall be charged against the current year's appropriations of the board. The National Drug Law Enforcement and Prevention Coordinating Center, the Narcotics Group of the PNP, the Narcotics Division of the NBI, and other drug abuse units of the different law enforcement agencies integrated into the PDEA in order to carry out the provisions of this act. Section 88. Management of funds under this act. Annual report by the board and the PDEA. The board shall manage the funds as it may deem proper for the attainment of objectives of this act, in addition to the period reports as may be required under this act. The chairman of the board shall submit to the President of the Philippines and to the presiding officers of both houses of Congress within 15 days from the opening of regular session an annual report on the dangerous drug situation in the country. Section 89. Auditing the accounts and expenses of the board and the PDEA. All accounts and expenses of the board and the PDEA shall be audited by COA or its duly authorized representative. special courts from among the existing regional trial courts in each judicial region to exclusively try and hear cases involving violations of this act. The number of courts designated in each judicial region shall be based on the population and the number of cases pending. Section 91. Responsibility and liability of law enforcement agencies and other government officials and employees in testing as prosecution witnesses in dangerous drug cases. Any member of law enforcement agencies or any other government official and employee who after due notice fails or refuses intentionally or negligently to appear as a witness for the prosecution in any proceedings involving violations of this act without any valid reason shall be punished with imprisonment of not less than 12 years and 1 day to 20 years and fine of not less than 500,000 pesos. In addition to the administrative liability, he or she may be meted out by his or her immediate superior and or appropriate body. Section 92. Delay and bungling in the prosecution of drug cases. Any government officer or employee tasked with the prosecution of drug-related cases under this act, who, without patient laxity, inexcusable neglect, unreasonable delay, or deliberately causes the unsuccessful prosecution and or dismissal of the said drug cases, shall suffer the penalty of imprisonment ranging from 12 years and 1 day to 20 years without prejudice to his or her prosecution under the pertinent provision of the revised penal code. Section 93. Reclassification, addition of removal of any drug from the list of dangerous drugs. The board shall have the power to reclassify, add to, or remove from the list of dangerous drugs. Proceedings to reclassify, add, or remove a drug or other substance may be initiated by the PDEA, the DOH, or by petition from any interested party, including the manufacturer or of a drug, a medical society or association, a pharmacy association, a public interest group concerned with drug abuse, a national or local government agency, or an individual citizen. Article 12. Implementing rules and regulations. Section 94. Implementing rules and regulations. The present board, in consultation with the DOH, DILG, DOH, DepEd, DSWD, DOLE, PNP, NBI, PALCOR, and the PCSO, and all other concerned government agencies shall promulgate within 60 days the implementing rules and regulations that shall be necessary to implement the provision of this act. Article 13. Final provisions. Section 95. Congressional Oversight Committee. There is hereby created a Congressional Oversight Committee composed of 7 members from the Senate and 7 members from the House of Representatives. The members from the Senate shall be appointed by the Senate President based on the proportional representation of the parties or coalitions. Section 96. Powers and function of the Oversight Committee. The Oversight Committee of Dangerous Drugs shall, in aid of legislation, perform the following function among others. First, to set the guidelines and overall framework to monitor and ensure the proper implementation of this act. Next, to ensure transparency and require the submission of reports from government agencies concerned on the conduct of programs, projects, and policies relating to the implementation of this act. Next, to approve the budget for the programs of the Oversight Committee on Dangerous Drugs and all disbursements therefrom, including compensation of all personnel. Next, to submit periodic reports to the President of the Philippines and Congress on the implementation of the provision of this act. Next, to determine inherent weaknesses in the law and recommend the necessary remedial legislation or executive measure, and to perform such other duties, function, and responsibilities Oversight Committee on Dangerous Drugs shall adopt its internal rules of procedure, conduct hearings, and receive testimonies, reports, and technical advice, invite or summon by subpoena ad testificandum any public official, private citizen, or any public or other person to testify before it, or require any person by subpoena to testicom documents or other materials that may require consistent with the provision of this Act. Section 98. Limited applicability of the revised penal code. Notwithstanding any law, rule, or regulation to the contrary, the provision of the revised penal code, Act No. 3814, as amended, shall not apply to the provisions of this Act except in the case of minor offenders, where the offender is a minor, the penalty for acts punishable by life imprisonment to death, provided herein shall be reclusion perpetua to death. Section 99. Separability clause. If for any reason, any section or provision of this Act, or any portion thereof, or the application of such section, provision, or portion thereof to any person, group, or circumstance is declared invalid or unconstitutional, the remainder of this Act shall not be affected by such declaration and shall remain in force and effect. Section 100. Repealing clause. Public Act No. 6425 as amended is hereby repealed, and other laws, administrative orders, rules, and regulation, or parts thereof inconsistent with the provision of this Act are hereby repealed or modified accordingly. Section 101. Amending clause. Republic Act No. 765659 is hereby amended accordingly. Section 102. Effectivity. This Act shall take effect 15 days upon its publication in at least 2 national newspapers of general circulation. Conclusion. Drug use and addiction cause a lot of disease and disability in